And where are you going? What do you want?
Hello and welcome to Trusts and Estates Weekly. I'm your host, Kevin Bemmel, and we are here every Monday at 10 a.m. Pacific time to talk about all matters relating to the creation, administration of trusts and estates, both from your own personal planning standpoint, as well as helping professionals like me. I'm a professional fiduciary, deal with clients and help other people out in their estate planning, the administration of their trusts and estates, etc. So today is a topic that unfortunately I'm having to deal with in one of my cases. And so I decided to explore it a little bit and increase my own knowledge about it and then share it with you. This is really just an overview of what I call informal wills. So I've talked on a number of occasions about the various types of documents that are used for estate planning and succession, namely wills, trusts, designations of beneficiaries on death. And all of these documents these days are very well established, although they differ from state to state. They've been used for a long, long time. And so there's not a lot of mystery surrounding them. And if they're done correctly, they're very hard to challenge, and they're part of a well-established system. Now, by the way, that does not mean that just because a document is drafted correctly that it's legitimate. So I'm dealing with a case right now where it appears that a trust that on its face looks legitimate was actually fraudulently drawn up. It was created after the decedent passed away, and her signature was forged. So, excuse me. So, but in general, a properly created trust, a properly drawn will, you're not going to have a whole lot of problems specifically with that instrument. Now, you may have, people may still challenge it anyway because they want some of the money or whatever. But in any event, those are well established. So informal wills, and to the best of my knowledge, there's no such thing as an informal trust. But an informal will is one that's created sort of outside the regular requirements for a written will. Okay, and as such, they are far more likely to be challenged, and they create a far less certain path for succession, meaning how your property is going to be distributed when you die. So I've got 4 examples that I'm going to talk about. Now, as we've mentioned many times before on this show, probate and estate trust law differs state by state. And so I'm going to first talk about just some generally about these 4 types. And then after that, I'm going to go into some more details with respect to California, which is the jurisdiction in which I live, although I practice nationwide, to give you an example of how things can differ state by state. Okay. And so let me start this out by saying this, of course, is not legal advice on my part. I am not a lawyer. I'm just giving you some general education on these types of informal wills. And if you are dealing with them, you absolutely need to get competent legal advice on them. They're very difficult to deal with, and there's really, just like there's no such thing as so-called settled science, there's really oftentimes no such thing as settled law. So the law changes over time. The approach, first of all, legislation can change. If something is impacted by regulations as well, regulations change. And then how society and judges view certain things can also change over time. And I'm going to talk more about that in this section when I talk about these 4 informal wills with respect to California. So the first type of informal will is an oral will, or what's called a nuncupative will. Now, oral wills are literally millennia old. In fact, I recall learning about them a little bit when I was studying the Talmud. And it was I was trying to remember, so I looked it up yesterday in the Tractate Bava Basra. In the Gemara, it talks, quite a bit about the laws of inheritance and such. And I believe there's a section in there that talks about, what happens if someone is on their deathbed and, either hasn't made a will and wants to, or wants to, give certain property away to a certain person, how all that works. So the idea of an oral will has been around for a long, long time. Now, there's a generally speaking, it's made verbally, hence the term oral will, but in front of witnesses. Okay, now they don't necessarily have to be, designated. You're a witness, you're a witness. It could be there's a doctor and a nurse there, along with maybe family members, whoever happens to be there. It's just that there has to be, there have to be people there who hear what the testator, the person making the will, has to say. That's number one. Number two, generally speaking, it's during it, the testator knows that he's dying, and so it's made in the sort of final moments of his life, and as such, death is imminent, and so we see this idea in other areas of the law. So, number one, there's a presumption that it's truthful. Okay, so there's something called a dying declaration, where somebody knows they're dying. They know let's say they've been shot. They know there's no chance they're going to survive. And maybe they witnessed a crime or were part of a crime. There's no way they're not going to make it to get into court. They can't be deposed where there's a court reporter taking it down. And they make a statement, maybe to a police officer or somebody else who's on the scene. And the presumption is that since they knew they were dying, what they're telling is the truth. Okay, so there's an aspect of that here, that in our final moments, what we really know, what we really want, that's what we're talking about. We're not going to waste our time, lying. Okay, now, as far as validity is concerned, there are jurisdictions that recognize them. However, it's a small number, okay, and they're almost always subject to very strict conditions, such as the testator must be in imminent peril of death. Okay, the witnesses write down what the testator said within a certain specific time frame, and it applies to personal property, but not to real estate, real property. Okay, so my car, my coin collection, my checking account, those kind of things. That's personal property, as opposed to my house, the office building I own for my business, that sort of thing, which is real estate. Okay, now The major limitation on oral wills is, of course, there's oftentimes no tangible proof. Okay. And so if there's a written will and somebody comes along and says, well, right before he died, my dad made an oral will, and that oral will supersedes the written will, in most cases, the court will probably look at that with a great deal of skepticism, unless there's real tangible proof that that the oral will was made, and it's in a jurisdiction where such a will even be considered. Okay, so that's the first type, an oral will. Second type is what's called a holographic will. So it's a partially non-written will. It's not a formally written will, and generally speaking, a holographic will is a handwritten will, literally handwritten, not necessarily in cursive. It can be printed, but as opposed to typed or printed. Okay, so if word processed, if a will is entirely word processed, so in that may not qualify. Let's say I wanted to draft a will, and I word processed a will, but that's it, and then I signed it. Okay, that may not qualify as a holographic will. Whereas if I hand wrote it out and signed it, then it might, excuse me, it might be valid as a holographic will. Again, that varies from jurisdiction to jurisdiction. Okay. Some jurisdictions will allow these holographic wills, even if they're not formalized, and that's typically the idea. Maybe someone is going away on a trip. It may be to a dangerous place, and they don't have time to sit down with their lawyer, and so they handwrite out a will and sign it. It doesn't require witnesses typically. And they leave it behind in an envelope that says, to be opened upon my death. Okay. And that's what, that type of will may be valid. Okay. Now, a holographic will doesn't necessarily have to supersede a valid written will per se. It could supplement that written will, okay, so that it's there for clarifying purposes, as opposed to be the sole document describing the decedent's intentions. Okay, and so perhaps the decedent has, let's say, 3 checking accounts, and he puts in there, they're to go to my heirs. Okay, but he doesn't say how they're to be divided up. Are they to be divided up a third, a third, a third? Add them all together and divide the amount up by a third each. Is one to go to each one of them? How is that going to work? So you might, a testator might do a holographic will explaining, that this is to explain in my will that I want, the value of all 3 accounts added up together, and each of my beneficiaries is to get 1/3 of the total amount. Or beneficiary A gets account number 1, B gets 2, and C gets 3. However they could do it to clarify something, in a valid will. Okay, so that's number 2, a holographic will. Number 3, and this is not, this is a type of will, but it's more a circumstance, is statutory exceptions for soldiers, sailors, Marines, in other words, people in the military. Okay, so in some jurisdictions, you can have members of the armed forces on active duty, and they can make informal or even oral wills and they might be upheld in that jurisdiction because of the unique circumstances. So I know when I was in the military and I was scheduled to be deployed to I think it was Afghanistan. I don't recall now. The deployment was canceled because my wife at the time was diagnosed with cancer. But part of the process of getting ready to make that deployment was that I had to have a will drawn up. Okay, and the reason is because that even though I'm not a combatant, um, non-combatants are killed in combat zones. I don't want to say all the time, but they certainly are. And so the military doesn't want to have a chaotic situation happen with respect to what's going to happen with a service member's property if that service member is killed. Okay, now if for some reason a service member is deployed and they're in combat and they didn't draft a will, so they might draft a holographic will, or they might tell a buddy, hey, I don't have any will, so I want to give you my last will and testament orally here, and I'm counting on you to see to it that my wishes are fulfilled. Okay, so again, it will vary from jurisdiction to jurisdiction. The circumstances will matter. And there may be specific rules regarding timing and applicability. Okay, all of those come into play. Okay, so this is something that a service member may end up relying on only because of the of unfortunate circumstances, but of course always better to take care of these things before you're deployed. And by the way, there's training accidents in the military. Up until I think just a few years ago, the number of deaths from training accidents was higher than the number of deaths due to combat. So I think recently that switched. Combat deaths are now actually a little bit higher over the period of the global war on terrorism. But it shows you that just being in the military is a dangerous occupation, and so one is well advised to have an estate plan and make sure all the documents are done and not rely on these kinds of informal wills. Now, with the advent of video and recording devices on our phones and all of that, inevitably the concept of a video or audio recorded will has come up, and this is something. Well, of course, video and audio recording is not new. The accessibility to it is relatively new since the advent of smartphones, and so now some jurisdictions are starting to look at, do we place validity on a video or an audio will? Okay. Now, if you watch television, I think it was in the 70s, there were various shows where they would have, people would be called to the lawyer's office for the reading of the will. And it turned out that the decedent had made a videotaped will, and I get because of how it was done, the lawyer had set it up as part of a valid estate plan, and so they were held to be valid. Now, by the way, I don't know if back then that was legally the case, but certainly in the context of a television show, it made for an interesting situation. Okay, so like anything, video and audio recorded wills, it's going to depend on, what the person said, what the circumstances were in which the will was done, and what are the rules, if any, about them in a particular jurisdiction. Now, that jurisdiction typically is going to be a state, because again, it's state law that covers these types of issues. And so if you're considering this type of instrument, so then again, very well advised to talk to an estate planning attorney and find out what are the rules in the state in which you live. Maybe you can do a video or audio recording, and maybe it's valid as a supplement to an otherwise valid will or trust, okay, to impress upon your beneficiaries your wishes. And for example, maybe you are giving them some money, and you want them to continue with the type of charitable work that you did. And it's one thing to put these things on paper. It's another thing to make a video plea, if you will, to your heirs, to the beneficiaries under your will. Okay, and so maybe as supplemental indication of your wishes, maybe it would have some validity. Again, that all deals with the jurisdiction in which you live. Now, having said all of these things, okay, I want to repeat something, and that is that by their nature, these are much more likely to be challenged than a conventional will, a conventional trust. Okay, and so this is why legal advice is so important, unless you are in some sort of emergent situation, and it's this or nothing, and so maybe you do it because you figure, okay, if it gets discounted by the court, I'm no worse off than I would have been if I hadn't done it at all, and so I'll give it a shot. I'm in combat with my buddy. We're going to be heading into battle in 20 minutes, and something has changed, or I realize I knew my will, whatever. So you go from that perspective. Okay, so that's an overview of the four. Now, what I want to do next, or I'm going to do next, is talk about California specifically, so you can see how a particular state deals with these four types of informal wills. Okay, now, the state where you live may very well be different, or you may not live in the United States. I know I have viewers for sure in Africa, maybe in Asia, Europe, whatever, South America. So how these are handled in your country would not necessarily be the same as they are here in the United States, especially here in California. Okay, so local advice is crucial in all of these. All right, so in California, so the recognition of non-written wills is limited, and there are certain strict guidelines, and I'm going to go through them now. Start with oral wills, nuncupative wills. So they are not recognized in California. So the California probate code requires that a will be in writing, even if it's made in extreme circumstances. So if you're in that foxhole, the classic foxhole, right? And you realize you did not make a will, a last will and testament, an oral statement to your buddy is, if you're a Californian, is not going to help. However, you may be able to write down your will and make a holographic will, which is the next one, and that may be upheld. Okay, so in California, holographic wills are recognized. I'm dealing with a case right now where someone's trying to get what they consider to be a holographic will recognized. Okay, here are the requirements. Now, these are the legal requirements. Now I'm going to talk about this afterwards. I'm going to talk about how this may be changing afterwards. So first of all, it must be entirely handwritten, meaning if it's typed or word processed. I don't know, does anybody have a typewriter anymore? I don't. But if it's word processed, in theory, that is not a valid holographic will in California. Excuse me. Okay, it must be signed by the testator, the person making the will. Okay, the OR ending of a word, okay, is the doer, the person making the will, as opposed to the EE ending of the word. The testatee is the one receiving the action. So the heirs, I guess, would be the testatees. Okay, it must clearly indicate testamentary intent, i.e., there should be some kind of language saying, this is my last will and testament, or this is my last will, or this will supersedes all other wills made previously, or something like that. It's not enough just to say, I hereby divide up my property as follows, okay? Finally, it does not need to be witnessed, but it must meet all the other legal requirements to be valid. Okay, now here's the thing. More recently, although the law has not changed, judges have begun to relax, the judges here in California have begun to relax the requirements for holographic wills. Okay. And so this is causing a lot of confusion and a lot of opportunism on the part of people claiming to be an heir under what they purport to be a holographic will. Now, this lack of clarity, you may on the one hand say, well, this is good because the courts are looking to help more people. Well, in this case, for everyone they help, there's probably someone being hurt. Okay, first of all, if an estate has to defend an action against a holographic will, that's an expense to the estate. Number one. Number two, it does, like I say, incentivize people to cook up what previously would have been clearly understood not to be a holographic will, just to try and essentially blackmail the estate into giving them something to go away. So whenever there's uncertainty in the legal system, it encourages litigation. And when litigation is encouraged, number one, it clogs up the courts. Number two, it costs money to deal with. And number three, there's a whole emotional component to this, which is it causes a lot of uncertainty and stress and anxiety on the part of the people who are involved with the situation. Okay, so it will be interesting to see what happens, not only with my case, but with this issue in general. And it may be that there needs to be additional legislation here in California clarifying that the heretofore fairly clear requirements of a holographic will stand, and that judges do not have the discretion to consider something to be a holographic will that is outside of those requirements. Or there may have to be a case, and would probably have to be a large case where it was worthwhile to spend the money to defend it, where a case maybe goes all the way up to the California Supreme Court, and hopefully the Supreme Court would rule that judges are acting beyond their discretion and causing a lot of needless litigation, et cetera, and costs, et cetera, to bring California holographic wills back within what were a long-standing understanding of their requirements under the law. Okay, but the reality is here in California, holographic wills are recognized, and then it becomes a matter of a case-by-case situation. Okay. All right. And by the way, a holographic will, may be challenged. And of course, one of the conditions under which a holographic will be challenged, since it does not have to have any witnesses, is, did the testator have capacity to make the will when the will was made, i.e., did they understand what they were doing? Okay. And could they even have written it down themselves? Did they have, like maybe it's written out in very clear print, and yet the person had some kind of palsy, right, that did not allow them to write clearly. Was this really the testator's writing? Did the testator have the capacity even to write the will? Okay, so this becomes an important issue dealing with holographic wills. Okay, all right. Number 3, statutory exception for soldiers and sailors. Now, like oral wills, California does not formally recognize, does not specifically recognize them. Now, a service member can create a holographic will. And if that holographic will falls within the requirements for the state of California, then that would be, at least tentatively could be recognized. Okay. But merely because someone is in combat, let's say, under fire, that does not change the fact that California does not recognize oral wills. Okay, so even under the very, very extreme dire circumstances that a service member may find himself in, he's gonna keep some pencil and paper, or pen and paper, and write down your holographic will if you want to have a chance at having your wishes upheld by the court. But don't rely on telling a buddy, hey, here's what I want to happen, and then the buddy shows up and, well, right before, God forbid, Kevin took a bullet, this is what he told me. California is almost for sure going to say, yeah, sorry, oral wills mean nothing here. Okay. With respect to video and digital wills, as of right now, they're not specifically recognized, or formally recognized, I should say, in California. However, audio and video recordings can be used to support the intent or the capacity of a testator, so that, for example, in the case of a holographic will, maybe there is a question of capacity, and so a court may may allow audio, a video will that shows that perhaps the testator was competent, did have the capacity to do this. They may admit that as evidence in order to support that a holographic will is in fact valid. Okay, so excuse me. Currently, California is exploring the idea of an electronic will, a will that there is no paper copy of it, like a DocuSign will, if you will. No pun intended. Okay. But at least as of when I did my research, the state of California did not formally recognize electronic wills either. Having said that, it wouldn't surprise me if eventually they are recognized. So for example, California does not allow online notary service, whereas, for example, Arizona does. If you remember, I had a guest a number of months ago. Let me get her name for you, just because might as well give her a shameless plug, as I sometimes do. Where is my? Oh, here we go. Okay, so let's see. What was her name? Oh gosh, I can't. Oh yeah, Suzanne Feinberg. Okay, so Suzanne does online notary services, and in talking to her after the show, I said, hey, this is great, because if I've got a client who is older and it's harder for them to get around, would love to have you available as a service provider. And she said, yeah, it doesn't work in California. California doesn't allow online notary service. So there are mobile notaries where the notary public will go to the person, but at least as things are right now, California does not allow online notary service. Now, I do think, if I had to guess, I would say that eventually is going to change. It's just It's so much more efficient, so much more convenient, just like online appearances in court, so much more convenient, so much less costly. California does allow those. So I think at some point we will see these innovations. Okay, so the general requirements for a will in California for it to be valid are it has to be in writing, typed, printed, or handwritten. It has to be signed by the testator or another person at the testator's direction and in the testator's presence. And it must be witnessed by at least 2 disinterested witnesses who were present at the time of signing. In other words, they could say, I saw the testator sign, or I saw party A sign on behalf of the testator while the testator was there saying, please sign on my behalf. Okay. Unless it's a holographic will. Okay. So holographic will, you don't need witnesses, but it has to be handwritten. Okay. So here's the rub. If you're in California and you do not have an estate plan, while in an emergency, you may rely on a holographic will, for example, that is not the best plan. Okay. It's more likely, it's much more likely to cause a challenge by other people. It's possible that the court will not uphold one of these informal wills, the holographic will. And so you are adding a large layer of uncertainty into your estate plan. So you are much, much better advised to meet with a lawyer and set up a formal estate plan, a formal will, a trust, whatever, depending on the size of your estate. Okay. And so, these days, because as I mentioned at the beginning, these documents are so standardized. Okay. Doing an estate plan is much less expensive than it used to be. Okay. And so it won't necessarily cost you thousands of dollars to do a sound estate plan. Depending on the size of your estate, where you're located, et cetera, you may be able to do it relatively less expensively. And the fact of the matter is, what the estate plan costs you to set up will almost for sure save your estate in greater expense at the time it's administrated, because there won't be the kind of uncertainty that leads to challenges, that leads to fighting between heirs or potential heirs, that costs the estate legal fees, administration fees, that clog up the court system, et cetera, et cetera, et cetera. Okay, so I talked again specifically about California because that's the jurisdiction in which I live. Your jurisdiction may be different: Texas, Florida, Nebraska, wherever you live. It would be very prudent to find these things out before they become a necessity, or before you decide to rely on something not knowing at all if it's valid in your jurisdiction. So that's the show for today. And this, of course, we could go through case law and look at nuances, and we'll save that for another day. But this gives you at least the basics. Okay, so coming up this week, tomorrow, Tuesday at 10 a.m. Pacific time, I'm going to be on Business Lessons from the Military, 10 a.m. Pacific. I'm going to be talking about succeeding a failed leader. And I'm going to be talking about Allenby at Gaza after Archibald Murray. So Archibald Murray was not successful in the Gaza campaign, and Allenby replaced him. And stepping into a leadership position behind someone who's failed, there are some leadership issues that definitely need to be addressed, and we can learn these from this particular situation. And then on Wednesday at 10 a.m. normally would be my show, People Making Money. But since it's the day before Thanksgiving, I'm going to be doing a special edition on Thanksgiving. And I'm going to be talking about the history of the holiday, as I always do, and reading George Washington's Thanksgiving Proclamation of 1789. So I invite you to join me for that. Originally, I planned to do it on Thanksgiving Day itself. And I said, no, people should be with their friends and families for the holiday and not be tuning in. So That will be on Wednesday at 10 a.m. Pacific time. And then a week from today, on Monday at 10 a.m., will be the next edition of Trusts and Estates Weekly. And my guest is Kaya Jordan. So, like me, Kaya is an independent fiduciary who also has a family office practice. And I think you will be very, very interested in hearing a little bit about Kaya's story and how he approaches the estate administration, the trust administration side of our industry. And so I invite you to tune in to hear Kaya. So I thank you very much for joining me today, especially those of you who join me live. Always a pleasure to be talking to you. And I wish you a wonderful rest of the day. And signing off as I always do. Marie, you are my bell. Courage at all times.